Lo and behold, I think I'm live. Good evening to everybody. I thought I could say it like this: not legal advice with a K, K-N-O-T, and not legal advice, N-O-T. I'm going to discuss a little bit about GTII current status. Not that I know anything specifically, but I think I can fill in on at least some of the detail. I was, and that's all I think I'm going to talk about specifically. There's obviously nothing, this is just opinion. Don't rely upon anything I said. I am trying to get the best result for other shareholders. That's the idea of GTII. We're involved in litigation in Nevada. In that litigation, a receiver was appointed. The receiver has been acting, I think, since the middle of September 18th of 2024. That's when he first got started. And he's been acting, trying to complete an audit, get money and shares back, and do whatever is necessary. Hasn't been that long. I know I spoke to our counsel today. He thinks that he's doing a very diligent and quick job, and he's on top of it. So just passing on those remarks. And it hasn't been that long. It's been long for all of us because all our stock sucks. So it seems like an incredibly long time, and it is. But the amount of time that the receiver has been involved is relatively short. And some guy, I guess, I find it annoying sometimes, and I don't look that often. But on Twitter, most people are really nice, by the way, and supportive, etc. And I appreciate that. It's always appreciated. It's been a rather tough week with all the fires. I had to put my dog to sleep and other stuff. So it's not been a pleasant week or past 10 days. But I saw something on Twitter and somebody was bitching about the timing and was comparing the timing that the receiver was in versus like Rabari. It made no sense. And one didn't bring in any money and whatever. Just didn't make a lot of sense, the allegations. But there's people who will clamor on Twitter and YouTube and wherever else. They might be, I give them the benefit of the doubt. Maybe they're just pissed off because it's been a ridiculously long time and the situation sucks. Or maybe they have other interests at heart. I never know. But it is what it is. But that I find annoying, just so we have it clear. And obviously, I'm not getting paid by anybody. Nobody's made any promises to pay me. I have gotten sued on this. So obviously, I didn't make any money on that suit, although I got it dismissed. So I feel that my position has validity. Just to go way back where we started this, we thought there, at least I and others, and then we communicated, and I'm sure you all thought at some point in time, it appeared there were shenanigans going on. We wanted to get, and we felt, I think collectively we felt, if there was no intervention, the company was gone. There was nothing that was going to save it. That was kind of, I think, our collective feeling. I think it was an accurate thought. So we wanted to get rid of everybody, get somebody in there, try to turn around. That's where we are. Don't know how long it's going to take. So we got rid of the directors, everybody of the old school. We replaced them. We're in the, 3 months, September, 3 or 4 months since then. And that's where we are currently. So told you about my last 10 days or so. And yesterday, a day before, I think it was John Bowen. If you're out there, John, hi. John Bowen sent me a text or an email, and I know John from MMTLP. And so MMTLP was my entree to trying to help shareholders. I was a shareholder of MMTLP, tried to pursue that. Obviously, this is not a money-making enterprise, or else I wouldn't have been pursuing MMTLP, and I wouldn't have been pursuing this, etc. But anyway, John Bowen sent out something, and he referenced a potential merger involving GTII and AI-versity. I think it's AI-versity. I have no idea who AI-versity is, but I kind of wanted to talk about two things. So first, we're going to talk about the merger, and then we're going to talk about the report of the receiver, which is dated January 13th. So it's a brand new report. Got it late yesterday, looked at it some today, although it's hard for me to read for whatever reason today. I don't know, but I'm having a difficult time focusing on the letters, but I'll do my best as we go through this. But first, we're going to go through the merger. So what do I know about this merger? I know nothing. I don't know who AI-versity is, although at one point in time during 6 months ago, no, less than 6 months ago, maybe 3-4 months ago, after the proverbial shit had hit the fan, somebody called me and they claimed to be an attorney, and their company or whoever they were managing might have had some interest, and I don't know if that's this company. But I don't know who AI-versity is. I saw the documents. I've spoken to our counsel. Our counsel in Nevada is going to ask for some additional information from the receiver's counsel and from the receiver, because in the documentation, and I looked through it. So there was an 8K filing. There were some attachments at 8K. I looked through that. I looked through the agreement. I looked through the attachments, and then I looked at the new receiver's report. And then I looked at the designation of Series B convertible preferred stock. So what happened is, kind of to set the stage, and none of this is nefarious or anything like that. It just is what it is, and we will deal with it as we go. And I want to treat it in order of the acquisition first, because that seems to be the question, and then we can deal with the report, which will relate to the acquisition some. But anyway, late December, and I wasn't aware of this, of course. And let me tell you my relationship with anybody. So my relationship is with our counsel, and when I have questions, I call him. He's always been available and been really quick to respond. And Alex Calloway, he's always been really good, and he's been really helpful, and he got the receiver appointed. So that's great. I think his firm did a great job. So I speak to him. I have spoken a few times to the counsel for the receiver. I had spoken to the receiver a few times. I'm trying to think who else I may have spoken to. I don't know who else I would have spoken to in a significant amount, but mostly our counsel for the receiver, and the receiver, especially in the early days, especially before the appointment of the receiver. So that's who I speak to. The receiver does his own thing. He doesn't consult with me, nor should he consult with me, to be honest, about whatever he does. Again, his actions have to ultimately be approved by the court. So that's the way we go. And unfortunately, I wish somebody was paying me big money for something here, but unfortunately, I say that half jokingly, I'm not getting compensated for anything. So to the extent somebody suggests that's a motivation, that's kind of silly, which leads me to, I forgot, the last couple of times I haven't done any attempted jokes, but I figure why not give it a shot today. What do you get when you play tug of war with a pig? Pulled pork. Pulled pork, of course. What do you call a pig that drives recklessly? A road hog. Why do you never tell a pig a secret? Because they love to squeal. And here's the one for those about you out there that are thinkers. What do you get when you cross a frog and a pig? A lifetime ban from the Muppet Show. Think about that one. All right. So I'm not consulted, nor is it proper for them to consult with me on anything they do at GTII. I learn about it usually very quickly, and I inquire and have inquired, and I speak to our counsel. So late December, and I found this out, I found it out in the filing, the 8K filing in the last couple of days, and I pulled it and copied it today, is a designation of a Series B convertible stock. So they issued stock, 1,000 shares, a preferred B. The preferred B, I think they authorized the issuance. I don't know if it's actually been issued yet. So there's two stages. There's an authorization where you get the authority to issue stock, and then there's actual issuance of the stock. So I don't know if this is just the authorization or the issuance, but they can at this point in time issue 1,000 shares of the preferred stock. No particular problem with that. Now, the terms of that are interesting because it really depends on what the deal is, because the significance of the preferred stock is in the transaction that's referenced in the 8K involving AI-versity. I wish I knew how to say that, by the way, and GTII. The remuneration to the company, and it looks to be like there's a bunch of different kinds of mergers. Not that I'm a merger expert, I certainly am not, but I'm familiar with this type for various reasons. I am familiar with this type of document, and the merger document is kind of a reverse merger. So in this particular arrangement, at least the way I read it, the company, being AI-versity, will get 1,000 shares of preferred stock. So the preferred stock, therefore, is of significance. Now, I looked at the documents. There's a reference to a financial statement that would go through, I think, September of 2024 about the company. It's not attached. I know our counsel is asking for it. It's not referenced, and that's obviously a significant factor. Also, kind of what the deal is. What is AI-versity? And by the way, that I'm going to have a request when after I finish talking about AI-versity a little bit to kind of, I think, help here. I don't know what the deal is. I don't know what AI-versity is bringing to the table. I don't know what they do. I don't know what they're going to get besides the 1,000 shares preferred stock, which appears to have significant rights. But I really don't know what they do. I would expect, although nobody's told me this, and we'll obviously find this out because it's not going to go forward without us knowing, but I would expect that they're bringing money to the table of some amount, because if they're not, they're just bringing their technology and they get the preferred stock in return. To me, unless I'm missing something, that doesn't sound like a fair deal. And I'm looking again, what's in my mind, and you can chime in anytime, what I think is in our interest as shareholders. So one thing that I thought, and I suggested it to our counsel, and they agreed, but this would be a way of making sure that we know that the best deal is being presented to the receiver, and that the court will have an opportunity to approve the best deal for the company and for the shareholders. So there's a hearing, I believe, the end of January 29th of 2025, in which the issue of the merger will be discussed with the court. And what I thought would make sense, and again, I got approval for it, but what I thought would make sense is for any legitimate company that wants to do a merger or a deal or anything with GTII, contact counsel for the receiver and do it immediately. And certainly do it before January 29th of 25. If you don't have the contact information for the counsel for the receiver, contact me and I will give it to you. And what I'd like you to do, so we can kind of keep track of this, if you're a party, and I don't have any involvement in terms of selection or anything like that, but anybody who contacts the receiver's counsel and offers some type of deal, after you've done that, please contact me and let me know you've done that. And that way, again, I'm looking for the best deal for the company and for the shareholders. I think in this way, I don't have the authority. I'm not doing it on behalf of the company. I'm just saying, seems to me right now, the best strategy, if you're interested in doing a deal with GTII, is to present it to the receiver. And what will happen is, if there's a bunch of deals that have been presented to the receiver prior to January 29th, 25, those all have to be evaluated, and the court will obviously be swayed by the best deal. So if you have a deal, or if you know somebody has a real, and I don't mean like a BS deal, but a legitimate transaction that they think in their professional capacity will, one, that they could do it, and two, somebody asked me, do I have prospects? I'm not getting involved in any of the substantive nature. I'm just kind of, because I don't want to, I just don't think it's a smart thing for me to weigh in on any side. That way, if I speak to you, you know I'm being legit. I don't want to have a horse in the race other than being a shareholder. So I don't. So whatever I tell you, it may not be right, but that's kind of what I believe. So again, anybody, and you have a limited time period, but we want to get the best deal for shareholders. So if there's parties out there, whoever you are, contact the Receivers Council now. And again, if you don't have that contact information, contact me. And after you have contacted the Receivers Council and made your pitch, let me know so I know, and we could let our counsel know. So on one, either they can object to the current transaction if it needs to be objected to, or two, we can advise of better transactions that are out there. Three, it might improve the terms of any transaction. So again, that was kind of my idea today. So I'm not going to be the one who's going to sort through any of the transactions. But again, I urge you, any of you out there who know anyone who would have any serious interest in combining in any aspect with GTII, now's the time. So reach out. And again, if you don't know the information for the council, I'm repeating this like 9 times. If you don't know the information of the council, reach out to me. And after you have, let me know so I could let our council know what deals have been presented, and so we can advise the court on the 29th. Okay. So that's our plan to ensure that if there is a deal that's accepted, because I don't know if this deal will be accepted, any of these deals, but if there is a deal accepted, that we have the best opportunity to have the best deal that works in our favor, not one that might benefit someone else. And I'm not making any disparaging remarks about the existing transaction. I just, I know that others have contacted me or suggested they had made certain contacts. So I would guess, my feeling is there are other potential transactions out there. So why not get the best deal? Why not let these guys compete against each other right now until the 29th? Again, there's no reason not for us shareholders to get the best transaction. And again, maybe this AI-versity is going to end up being the best transaction. I don't know. But we have an opportunity kind of do a auction in some way, a reverse auction in a way. So let's see what we can do. So the terms of the Series B preferred stock, and I'm reading, this was a copy of the 8K, an attachment to the 8K. And obviously this could be amended too. And I don't know, and nobody disclosed this to me before. I don't know why these terms are as they are. They obviously can be in whatever manner they are. But this is what the current deal would be. In this case, AI-versity would be getting 1,000 shares of the Series B. There is only 1,000 shares of the Series B. And what rights, and by the way, just because the rights, whatever the rights are, doesn't make that nefarious. It just might be something that you may not like or you'd want renegotiated. And we'll see how that goes. But voting rights. So the voting rights is each share of the Series B preferred stock shall have super voting rights in an amount equal to 100% of the total outstanding shares. So it sounds like basically that 1,000 shares is going to basically super control the company. So is that necessarily bad? It's not necessarily bad, but to get that benefit, I would certainly like them to bring a lot to the table. If it's Elon Musk who's coming to the table, and I'm not suggesting, by the way, that Elon Musk is coming to the table, although Elon, if you want to go take GTII, you're welcome, we would welcome you as a new owner. But whoever it is, they would have control, and it depends. It depends if they're bringing, millions of dollars to the table in business, and that will reflate the stock, get it trading again. I don't know, but it certainly is it's obviously clearly control, and it's something that I don't think you should give up without seeing what the benefits are to the company. And I think our council agrees with that. The second, so that caught my attention, and we have to certainly get information about that. There's other sections, by the way, but there was 3 sections that caught my eye, and those are to me, the most important, and that's kind of what I need clarified. So we got the voting rights, which basically gives control to somebody else. That might be okay depending on how much they're contributing. Dividends, basically that each Series B holder gets 2 times the dividends of a common. Maybe, I don't know. I don't know what kind of dividends are going to be issued. And I don't know if those are going to be calculated the same way as the voting rights, where 1 share might be equal to 100% of the stock, where instead of twice might be actually 200. From what is here, it's not clear. And again, this would have to be clarified and clarified. But the dividend is like a secondary importance, because that wouldn't be right away anyway. And if there's a dividend that can be paid out, it's not necessarily a bad thing at some point in time. Still, voting rights to me is more important than that. The third one is liquidation, that each holder of Series B preferred stock shall, on a pro rata basis, receive a priority of $4 million to be paid before any common. I don't know what that means in terms of the 1,000 share. It's unclear to me. Of the 1,000 shares, is that 1,000 shares has priority for $4 million, which we can argue about, unless they put up $4 million or something like that, or other consideration, then maybe it makes sense. Or does that mean that everybody with 1 share now has a $4 million priority in distributions over common? Not clear. The first one, if it equates to whatever they're kicking in, okay, maybe. The second one, where it's, ridiculous sum combined, I would not be for. So those are the 3 sections of the Series B that would go to the company that's being, in essence, what happens is this private company is going public through Gtii. That's what's going on. So it depends on what they're bringing to the table. And right now, based upon what we know, we don't know, because we don't know what the terms are. We haven't seen a financial statement, and that I'm sure that's inadvertent, that we haven't seen a financial statement. It's been asked for, and we will see what it is. But again, depends on what they're bringing to the table. It may very well be reasonable and appropriate, but at this point in time, it's not known. And it certainly are issues that need to be analyzed, because voting rights and the liquidation rights, they are important, and they caught my attention. So those are the 2 things that we are working on. Our council will be getting certainly clarification about that. And again, if other potential acquirers or business doers end up contacting the Receivers Council to inquire about doing a transaction, will they get the benefit of these shares, or will there be some modification? I don't know. But those were the issues I caught. Other people might have different issues, different concerns, but control and the kind of the liquidation, because I don't know, thinking out loud, most of the time it's like you don't know what's going to happen. So what could trigger a liquidation? I don't know. But if there's cash and there's people there to get it, and us shareholders aren't entitled to any afterwards, it causes me some concern. If it equates to whatever the contribution is, in a cash contribution or otherwise, then that makes sense to me. So we'll have to see how that plays out. Those are the 2 issues. So that's what the transaction, or the proposed transaction, with AI-versity sits. That's where it sits today. January 29th, as I said, this month, there'll be a hearing on it in Nevada. I've indicated my willingness to attend. I'll let our counsel know. And we will get clarification on these issues. And when I get some clarification, I will let you know. And again, anybody who wants to do any, wants to present any proposal, do it now and let me know after it's done, just so I can keep track of it, advise our counsel, and so we can advise the court if there's a better deal out there. Okay, I've kind of rambled about that long enough. Now let's talk about, so that's one aspect. Now let's talk about the the receiver's report. So that's January 13th. And I think this is actually, the transaction is referenced in the report. I saw it, first time I saw it was last night. First time I looked at it was today. So it's just kind of a cursory look. Based upon my discussions with our counsel, he's very satisfied with the amount of effort. So this is separate and apart from the acquisition. This is the efforts of the receiver in doing his work. And again, he's been there since September 18th of 2024. Basically, he looks at the status of the audit. Status of the audit is the auditor is accused of not cooperating and of not and of taking an adversarial posture and of encouraging a breaking of the accounting rules. Now, to me, that sounds problematic. And I don't know if it's true. And what happened was, apparently this particular auditor who was hired by the prior crew was preparing an audit because the prior auditor, remember, got blown out by the SEC. They did some work, but there was some questions that remained, some information that had not been provided. Apparently, during a time period in which they did not perform any services, at least that's what the report suggests, they asked for an additional $46,000 to complete their work. They then took and our receiver was annoyed because there was no work done during that time period and was concerned. They then ended up in an adversarial relationship. They refused to provide documents that were requested. So what can you do about that? Do they have liability, civil liability? Because who is the duty owed to the shareholders? Could this accounting firm be sued by some shareholder if in fact, and I don't know this, by the way, so I'm just reading from the report. The report's part of the court record now in Nevada. I don't know if anyone has sued them or will sue them. But if they had a duty to the shareholders and they have violated that duty and also suggested improper conduct, then perhaps they do. And perhaps somebody should look into them. Because if you recall, they took over for an accounting firm that got shut down, Borgers. If you recall, Borgers got kicked out. This is the accounting firm that got substituted in for Borgers. And our receiver is saying they're not playing by the rules. So, I think if they're not playing by the rules, then they should be penalized too. And if anybody out there wants to pursue that, they should feel free to pursue that. Because if what is truly stated by the receiver, then they are harming the interests of all our shareholders by delaying things, by not completing the audit. But as a result of that, our receiver hired a new CPA. They are expecting to complete the 2022 and 2023 audits within 30 days. So that would be by about February 8th. So that's about 3 weeks. And they're working to complete the full 2024 full year audit, all the quarterlies, and they expect all those to be completed before the March 31st deadline. So it appears that, and maybe the delay, and I don't know because I wasn't involved. I didn't deal with this accounting firm that the receiver is critical of. Because they said one of the things the auditor said, I mean, the receiver says, the auditor has also asked us to diverge from generally accepted accounting principles and conduct our own audit confirmation process with individuals as opposed to following the rules in defiance of PCAOB guidelines. So there is a organization that deals with accountants that do auditing. And, a lot of times it's the shareholders, the little shareholders getting screwed when the auditors don't do their job, because usually there may be litigation, but usually you're not getting a dollar for dollar in litigation. And oftentimes it's the accounting firms that haven't done their job that creates the problem. So, can anybody report any accounting firm to the PCAOB? You certainly can. I mean, I don't think there's anything against it. And if the receiver is correct, that's not appropriate conduct. And if this company is, if this is correct, and this company is doing it to other firms, and perhaps other shareholders are suffering the same consequences or might in the future. And this is kind of like anything else. You could do something wrong 100 times and there's no consequences, but maybe on one occasion there is. Just like in the LA fires, the mayor, not a big fan of, she's a member of some federal committee, and while there was notices of impending fire, there were notices of impending wind, a big wind storm coming to LA. And it was on the news for quite some time. We get those occasionally, but this one was like more highly emphasized enough so all the Northern California Cal Fire moved all their equipment to Southern California. So they were aware of the risk, and the mayor was aware of the risk. And despite that, she attended with a federal group, not anything to do with LA, a wedding of a dignitary in Ghana. Now, she left a day before the fires, knowing the risk. And even the day the fires broke out, she did not come back. Now, most times when the mayors probably go on their own junkets for their own reasons, there's nothing happens. That's it. But one time, the whole city burns down. And in this case, like Borgers, who is the prior accountant, sometimes there are really direct ramifications. So the fact that this accountant begged off should cause everybody concern. And, again, you as a stockholder, you can pursue your own remedies, or at least have somebody of a professional nature investigate this if it's not done properly. Because again, you may be saving yourself or a family member or a friend who might suffer the same consequences on a different company at some future time. But that seems to have been rectified by the receiver hiring a new CPA and a professional company. And we'll see. We'll wait to get all the documents. We'll wait to see what it says. We'll wait to see whatever revisions are in the audit. And I can't wait to see it. Usually, in my experience, if the numbers are bad before the audit, after the audit, they're worse. So I'm expecting to see more, not less. But anyway, that's moving forward, and that's necessary so we can get this back trading again, which I obviously hope we can do, because we're stuck in that expert market where only experts, in quotation marks, or brokers can trade, and they trade in usually low volumes, and the stock moves seemingly for nonsensical reasons. By the way, getting back, I should address that before I go back to this document. The fact that we have, though, companies still interested, because I referenced this before, I didn't know AI-versity was a company. The fact that there are still companies interested in GTAI should be a positive note for everybody. There must be some reason why they're interested. And anyway, hopefully that will amount to something that's productive for all of us, even if it's not AI-versity. But again, anybody out there? So getting back to the report of the receiver. So the receiver just says that they've, chased down a bunch of assets. Since the second report, they've collected approximately, and I'm just using rough numbers, about $150,000 more They've collected about $635,000 more. And I'm going to go through the prior report, which I haven't had a chance to go, and compare it with this and see what other items may be outstanding that need to be pushed that are not being pushed. So some additional monies have been collected. Also, they have gotten, this might be of benefit or interest to some, but they have repossessed, I guess, the Land Rover that Mr. Reichman had. Apparently, it has a value of $113,000 that's going to be sold. They still have retained approximately 15 million shares they've recovered. They are in the process, although I don't know what it is, but I certainly will ask for some clarity. The receiver says there's approximately 182 million shares that were acquired in dubious circumstances. I really don't know what that is, but that I take dubious to mean that there may be some question as to their legitimacy. Now, he says there's 182 million. That's most of the shares that the company has issued. And I don't know legitimately. And so they've returned 15 million. There's people that they have, I think that they think they're going to be able to get the shares back from. They may do that voluntarily, that somebody agrees to voluntarily return it so they don't get sued, or they might have to sue them. And obviously there's different people with different amounts. We all know that. And but they haven't filed any actions other than the actions that you're all aware of. There haven't been any actions filed against other parties, and there may be other parties that need to be included. And I'm going to address that in a second. So 182 million shares that are questionable. So I'm going to ask for a clarification as to, and I think I asked our counsel, is how many of those they think they're going to get back, because I don't give a crap, whether they're of dubious, but can they get them back? And I'm going to suggest that if they need to pursue them through litigation, they should pursue them through litigation. And I think our counsel is on the same page as to that. And it would be the receiver pursuing that also. The receiver then says that they have identified approximately, it's slightly over $12 million in stock sales or proceeds from stock sales that appear to be illicit and otherwise unreported. Now, could they be unreported and not be illicit? I guess so, but it's not. I think the suggestion is they may be problematic beyond just being inadvertent. And they address what they are: approximately $3 million involving a company that's a wholly owned subsidiary of Gtii, which none of us knew about. Well, at least I didn't know about it until this matter. We've talked about it at some length. .8 Inc., which is currently controlled by Justine Reichman. I believe she is the daughter of David. The transfer of 1.9 million approximately to Reichman from an attorney by the name of Mark Richardson. 2 million in that deal involving Markowitz. 5.2 million by Justine Reichman. And $230,000 in stock sales directly to Mr. Reichman. That's $12 million. Now, some of those parties referenced in there, because I know I spoke to our counsel, he's going to urge that litigation be commenced against them. My preference would be, that no time be wasted and that it immediately go forward. There's no reason not to. And $12 million, that's a significant chunk of change. And if in fact this money can be, the way I would look at about it, and I think we need more detail about the collectability and what they're going to do to collect that. And that's, by the way, it's fine because it's been a short amount of time, as our counsel has indicated. So I'm not complaining that they haven't done it yet, but we need to know what they're going to do, and they need to get off. They need to move quickly, and move, because that's a lot of money. $12 million certainly would put GTAI in good standing. would let it do whatever operations it would need to do, and it would make any transaction that GTI would need to do. We could control more of those terms if we didn't need the cash. So I'm going to urge, and you could all urge you all can contact the receiver, and I would encourage you all to contact the receiver. I think most of you know the receiver because I've seen it, that name referenced, or the receiver's counsel. But I think you should, with regard to item number 6 and the $12 million in stock sales, we all should encourage aggressive pursuit of that, because that's a significant amount of money. There may be other issues involved with it. I don't know, beyond just civil issues too. There's other claims against the officers and directors, et cetera, and I think those all should be made. And the ones that aren't represented, in particular, I think pressure should be put on them too. That's my view. So, like, for example, if a director didn't have representation and has potential liability, I think you should go all out after somebody like that. I think that person might be very cooperative. Wouldn't want to incur a lot of money. And so that would be my deal. I've not had any legal discussions, only my suggestions, but I haven't had any strategic discussions with Receivers Council about how to handle it. But my inclination is to go balls out against all the officers and directors, especially the ones that aren't represented at this point in time. And listen, if somebody wants to cut a deal, let them cut a deal. That's my view. Might be different than other people. To let you know what the and I'm going to communicate that too, and feel free you also to communicate that. I'm communicated that already to our council in Nevada, and I'm going to ask them to communicate that to the Receivers Council. But you certainly can communicate that too, because the more the merrier, the more impact the better, in my opinion. Because I think we need to stand up. And, the whole point is here, we're trying to make a stand. So we're making a stand against the system. So we have to be assertive. We have to be patient, but we have to be active. So let them know, be reasonable, be nice, but let them know. They've pointed out the problem. They've indicated that those transactions appear illicit. So they've made that determination again. So there's no reason not to pursue it. Now, I'm going to put a stop here for a second. Thinking about this, and this has been a discussion. Sometimes you think about it. Should you call the SEC? Do you want to call the cops or anything like that? Not encouraging either, by the way. But when you think about something like that, if the feds got involved, will they mess it up? And we don't know how it's going to work. Will a new administration, are they going to be more or less interested in situations like this? I don't know. I really don't know. But we should give it a shot if we can, if you think. But the question is, if the SEC or some other entity got involved outside of the courts, and I mean the civil courts, the risk is they could take over and recoup, take whatever. They would be the winners, and shareholders would be the losers. So I know, and I've thought about it many times, a desire to either, to take it a different way. But my view is, anybody could do whatever they think's appropriate and correct. But my view is we want to get our money back. And however we could do that in a civil way, that's why we're doing a civil matter, that's the way we should do it. And we should create a factual case as strong as possible while keeping it in the civil courts. That's my view. And if things change to any point in time, if it turns out that none of this is recoverable, then my view on that would change also. But at this point in time, I have no reason to believe that there aren't assets out there that can be recovered. It may not be the full amount, because unfortunately, in cases I've been involved before where there's been ripoffs, in my opinion, often assets were dissipated over time. So it's important to act quickly and promptly and aggressively. All right. So back to the report. So what has since the second report, which is about 45 days ago, 30 to 45 days ago, I don't remember an exact date, they have subpoenaed, so they've issued subpoenas to various financial institutions. And the way it goes, you have a subpoena, you have it served on an institution. They could accept it, they could oppose it, they could comply, all those, they could file a motion. So, and the way it works is you may have 30 days to respond. You can do one of those actions that'll extend the response time, and depending what you do, that might take some time. So since the last report, these have been served to JP Morgan Chase, Fidelity, Flagner Bank, TD Bank, American Express, Charles Schwab, US Bank, Citibank, Bank of America, Barclays Bank, City National Bank, Citizens Bank, Wells Fargo, Capital One, Coinbase, Morgan Stanley and Company. All those subpoenas are outstanding. Some of those several banks have not fully complied with the subpoenas. Now, it doesn't say that they are not going to comply. It doesn't say how many out of those have not complied. It doesn't say if there have been objections, but we will find out. But they're in the process, and if they in fact think there's information that is needed, then they can file motions in court to pursue the collection of that information. It really depends on what information you think's there, what the cost will be. You got to make a kind of evaluation. They also subpoenaed from .R records, and this is number 3 in this report on one of the pages. There's no page number I can see in front of me right now, probably because I cut it off, but I don't see a page number. But it says, moreover, Justine Reichman has asserted objections to many of the aforementioned subpoenas on behalf of herself and .8. And if you recall, there's that prior item of $5.6 million or something that involved or allegedly involved her in some way. I don't know in what way, but in some way that's referenced in this report. So is that the reason why there was objections to that subpoena? I don't know. Should those be pursued? I think they should be strongly pursued. And again, I know our counsel has indicated to the Receivers Council about pursuing several other parties. I don't think this particular party has been named yet. And I don't know what's going to happen, but it's certainly a lot of money. They may be perfectly justified, but it's certainly a lot of money and it deserves really close scrutiny and would make a hell of a difference in the operations of GTII if all those monies were obtained. So that's that. Now, one of the investigations, the receiver, and this is I'm still reading from the report. One of the things that the receiver has looked at the trust account of Justine Reichman. And this trust account, apparently, this is what the report says. I don't know. The synopsis says, David Reichman established a trust account for his daughter, Justine Reichman, in March of 2024. Mr. Reichman exclusively funded the trust account with the proceeds of illicit GTII stock sales and utilized it for the benefit of himself and his daughter. And some of the items that are cited, and again, I don't know the truth of any of this, but we've seen the allegations, and the allegations are pretty specific. I haven't seen a response that references these specific allegations, and so maybe there's perfectly justifiable reasons, but a $10,000 deposit, a $250,000 deposit, a $20,000 wire, the $1.8 million that Reichman received from the Markowitz transaction involving the GTI Employee Profit Sharing Trust Plan, a $75,000 deposit, a $60,000 wire, a $45,000 wire. So there's a lot of money that has to be explained and accounted for. That might make sense, though, why somebody would object to the compliance with the subpoenas. If you had nothing, and again, maybe perfectly legitimate. Sometimes people just object for objecting's sake. Sometimes people object because they don't want the information to come out, and you never know. Perhaps that information will get suppressed, perhaps not, but you never know. So if you're in a position, and I know, like when I've represented clients, if you're in a position and you have information you want to keep quiet, you make the other side work for it. And if they don't work for it, you don't give it to them. That's kind of the practice in a respect. There's no obligation to kind of like to throw your client under the bus. So you actually have to work hard. So they've obviously discovered that. I'm sure if they discovered this, I'm guessing in the audited financials, we're going to see a lot of stuff that's not even referenced yet. My guess. So it appears that, and I'm reading right from the report, it appears that after having moved illicit proceeds to Ms. Reichman's accounts, since the appointment of the receiver, so think about that. So the receiver was appointed, and since the appointment of the receiver, there's that trust account that was established, what the receiver says, through the illicit sales and transactions involving GTI stock. Through that same account, since the appointment of the receiver, so my question would be, is that a violation of the court order? Is that a circumvention of the court order? Is that contempt of court? I don't know. These are all questions that I'm certainly going to ask. But since that, and this is only referring to September and October of 2024, 74,000, and I'm using round numbers. These aren't the exact numbers. These are just round numbers. $74,000 in payments to American Express, $9,200 in payments to Capital One, $4,300 to Citibank, $900 to Barclays, $792 to US Bank, and various health insurance of $31,000. So as of 11/29/24, the balance in that trust account was $143,000, 143 approximately, and Mr. Reichman had full and immediate access to that money. So obviously, that has to be investigated. There's no question. The trustee then goes on to reference the, I'm reading the headline, GTI stock sales and Justine Reichman's home. And basically the receiver is talking about, there was an attorney who worked for GTII. They managed some type of transaction, and in that transaction, it appears that a number of shares were generated, and eventually, in some fashion, the cash that was generated from that transaction, which might have been on the order of $1.9 million, was moved around and eventually ended up, I think that this is the end of the point of this, ended up in the purchase of a piece of property at 60 Elm. This is what it says. It's item number 12 on a page. I don't have a page number on, but it says that the funds were used to purchase 60 Elm Avenue in Lake Larkspur, California on July 23, 2021, according to the below buyer's statement. So there's a buyer's statement in there, and it shows the purchase approximately 2.5 million, I think about 2.5 million. What's interesting is they cite a email, and so this is a house now owned by, I think, Justine, bought for $2.5 million, the money kind of coming a mysterious path, and I'm being generous about the mysterious path per this report, as this report says. And there's an email attached, and in the email, looks like July 19th, I think, of 2021. And it says, and this email apparently comes from David Reichman, and I only say that because it says, "Thank you, David Reichman." I don't know if it actually comes from David Reichman. I don't know if this is accurate, but it says, and this is what it's in the report, I just was about done. I was just about to close my computer here at midnight, and I saw the above. The document you sent me for my signature appears to be a full assignment of my purchase to Justine Reichman as an individual instead of her trust. Please check these documents. Please check these documents to be sure they are correct in that the buyer is the trust, Justine Reichman as trustee. So the point of this is that in this email, it indicates that the buyer was intended to be, or at least suggests, that the real buyer was David Reichman and that he was going to assign full interest to the Justine Reichman Trust. They made a mistake. They only had a Justine Reichman, and they needed to correct that. So the allegation is illicit money, even though title is held by, I think it must be the Justine Reichman Trust, but I don't even know. But I think that's who has title. That really was bought by David Reichman, and it really went or was going to for the benefit of Justine Reichman. And there is a question about the legitimacy of the funds that purchased that particular property. And it's referenced in the receiver's report. Just reading from it right here. And again, I don't know the accuracy of it. We don't know if it's true. I don't have firsthand knowledge. I didn't do the investigation. But, we've been talking about this since, I think, February of 2024. That's when I started doing videos, when I suspected shenanigans going on. And it seems like each day that goes by and each investigation that occurs, the more depth of issues that arise. And this is just another one. So who's entitled to the property? What's the property worth today? Should GTII go after it? I have a view on it. I think if it's a GTII asset, then GTI should go after it. And based upon what the receiver has suggested here, sounds like the funds are GTI funds. At least that's what the receiver suggests. And if that's the case, then that property and the appreciation, to the extent that property's gone up in value, then GTI should be the beneficiary of that. And again, I urge you, to the extent you have a position on that, communicate it to the receiver. If you think the receiver or his counsel should pursue that, let them know. Make yourself known. I communicate that, but again, even though I'm a blabber and I talk a lot, obviously, like here, the more the merrier, just like the action. The more position, the more push we get, the better, because we want to push, because we want a good outcome, and we need aggressive, super aggressive handling, especially whether we're talking about multi-million-dollar assets. No reason not to put a lis pendens on the property. Lis pendens is if you file a lawsuit and it's involving possession, title, and possession. I'm writing myself a note, by the way. Involving title, possession, you record it against the property. And if somebody's is going to do a transaction with regard to property, they see that notice on the property, and it kills any particular transaction. It would also prevent any type of refinancing to pull out any additional equity. And any transaction so I'm putting notice out now, any transaction, any sale, any refinance, any loan on that property happening after 4:58 p.m., 1/15/2025 was done intentionally and to violate the interests of shareholders of GTII, because I just put out notice. That's the notice. But I think there's a good idea that a lis pendens should be placed on that property. And a lawsuit should be immediately filed and a lis pendens placed. That would, if I were counsel, somebody contacted me, if there was an issue about the legitimacy of a property, and I wanted to make sure that no property was not lost, I would file. You have to file an action. You can't file a lis pendens without a lawsuit. So you have to file a lawsuit, but you need to file an action. And it would be basically that the assets, it should be in the constructive trust of GTII. and the court would be involved to watch out over the transaction. Would it have to be the Nevada lawsuit? I don't think so. I think it could be a California lawsuit, separate lawsuit, and I think it. And I will advise our counsel and the trustees' counsel tonight, as soon as I finish this, that needs to be done ASAP to preserve this asset. Okay, so and I'm glad you reminded me of that. Actually, that happened as I was, we were talking about this, that occurred to me. So that's important. And there's a statement, a closing statement. So we don't really know whose it was, but it sounds like it was David Reichman's, according to the receiver. And then it's Justine's, but the source is questionable, and it's bad. It's just not a clean transaction. So they need to get Mark Robertson's documents, but I don't think they need to wait. I think they need to move fast. They indicate, and I don't know if this is an addition or a prior, and I'll get more clarity on this, but they indicate on the next page, which is also, I don't have a number per se, but it's number 6 on the next page of the unnumbered page. Significant beneficiaries of the defalcated funds include. Defalcation is a term that means, in essence, like an embezzlement or taking funds that are entrusted to you. That's what it's used. It's not a positive term, it's a legal term. And it says that those who have gotten the beneficiaries of these embezzled funds, using like a straight dictionary term, but it says defalcated. A, Justine Reichman, $250,000, September 6, 2022. B, Justine Reichman's company, Next Gen Chef Inc., check for $250,000, 9/6/2022. Reichman's personal consultancy, First American Business and Management Consultants Inc., check for $500,000, 9/21/22. That's the same entity, by the way, that attorney or apparently an attorney for GTII, Mark Richardson, sent when he sent the $1.9 million, which the receiver says, I'm reading from here, was laundered GTII stock sale proceeds. D, David Reichman fund transfer to self at unknown account for 10 million. It says 10 million. Check for 10 million. I don't know if that's 10 million. If that's 10 million, that's a big deal. I don't know if that's 10,000. It's a transaction involving March 18th, 2024. I don't know. Homeowners Association, like $11,000 fee. A transfer by David Reichman written to himself is $75,000, dated September 5th of 2024. So that's during all this, the lawsuit and everything that happened. $20,000 for a Porsche payment to a car registered at Justine Reichman's address in Marin County, California. A masseuse, payment for a masseuse, payment for a personal trainer, payment for a masseuse. So masseuse payments, we've had prior masseuse payments. I don't know why these piss us off so much, but it's such a, if true, it's just such a blatant disrespect for shareholders. Really, I mean, have a little courtesy. Really, if you're gonna. And again, I don't know if these are true and accurate, whatever. Maybe they're corporate expenses, but is $720 masseuse, is that a corporate expense? Is an $1,800 personal trainer, is that a corporate expense? Is $1,690 masseuse, is that a corporate expense? Is a physical therapist bill of $1,400, is that a corporate expense? Some more, like $3,300 for something else, $5,300 to an assistant, $15,000 in homeowners association payments at the Wilshire Boulevard condo. How does that relate to the company? How does that relate to GTII? His personal residence or somebody's personal residence on Wilshire Boulevard. $6,000 in Shell MasterCard auto payments. $21,000 in Saks Fifth Avenue Capital One credit payments. $87,000 in Amex credit card payments. So they're claiming that that's all money that was they're the beneficiaries of money that was embezzled. And those are items. And I will follow up and find out what they're doing or what they can do in terms of getting those monies back or pursuing the parties that benefited, one or the other. Item number 7 says that Reichman also transferred like $950,000 to his personal TD account, and then he transferred $1.7 million to another time. And it also says and I don't know why, don't know what the justification was, but it's amazing. That's all I could say. On November 14th of 2023, and I don't think we've talked about this ever before, Reichman wired $3 million to his personal Fidelity account. And what the receiver is saying, that he believes all that money, and again, some of that must be reachable, but they believe all that money was coming from an embezzled circumstance. And I have to find out the status of all that. There's a bunch of other money. It says that Reichman, his American Express payments, and maybe this is somehow, again, maybe you could justify some of this. Between 2022 and 2024, it appears to be personal expenses. Yeah, appears to be personal expenses paid by GTII over those 3 years, $715,000 on that American Express card. I mean, outrageous, if true, outrageous. And again, each moment, it discloses new things. And for example, it has an item, and just references one item, $6,743.75 for a company called Ripless, and it says for meeting expense. And Ripless is a high-end men's clothing store. So rip more is more, I think, what it should have said, not rip less. So I will find out the status of the pursuit of all of those. But it might take some time, and getting the audit and all those other things done may happen before all the pursuit of these things occur. So I will go that. I'm trying to see if there's anything else that really caught my attention. Not really. I'm trying to see anything else. Oh, the .8 involving stock sales from July 21, October 22. This is a subsidiary of GTII that we didn't know about, that I think is controlled by one of the Reichmans. I believe it's controlled by one of the Reichmans. And there was a sale of about $3 million in 21 and 22. And that Justine Reichman received the proceeds of about $2 million. It says, number 5, a little over $2 million in GTI stock sale proceeds were misappropriated to Justine Reichman between July 2021, November 4th, 2024. That's a lot. And then another reference to $875,000, $866,000. This October was the balance, I guess, in October of 2024. Anyway, this is just a list of, and there's a bunch of checks signed by, apparently there's checks also that are signed by Justine Reichman. And it references like $200,000 just of PayPal and Venmo transactions, $661,000 of Citibank credit card payments, like $289,000 of Amex, and some others, and a whole bunch of other stuff. It also includes, by the way, one of the expenditures in here, and again, might catch your attention, $571,000 spent on home construction improvement and thousands going to a podcast room where Justine Reichman hosts a podcast associated with her company, Next Gen Chef. And all the utility bills apparently were paid out of the Fidelity account that had the money that came from, apparently, from stock sales. So in summary, the receiver says, in summary, David Reichman and Justine Reichman directed illicit stock sales by .8 Inc., the company's wholly owned subsidiary, for their material benefit, making .8 one of the primary sources of funds that subsidize their lifestyle. Yeah, so that's pretty egregious. I can go on and on, but I think that's enough of the color. So we've gone through. What have we gone through? We went through the transaction. I encourage anybody to contact the receiver about anything, and the receiver's counsel, if you have a entity or a deal you want to have discussed or involved in with GTII, to let me know if you do it. Then I went through the receiver's third interim report. We talked about some of the categories. I encourage anybody who wants anything pursued to let the receiver's counsel know if they want anything pursued, any of those items. And I'm going to contact again, and I'm going to follow up on all those items and let them know the things that they should pursue, including the item that I referenced about the Liz pendants when we were talking. If any of you have any further questions, let me know. I didn't look any questions because it was a lot of information. I think it was a lot of information. Maybe I'm wrong. But it was a lot of stuff, and I probably bored you guys to death. And all we can do is do our best, keep on pushing, get our point across, make sure you're active, be nice and cordial and businesslike, but be active and aggressive, and seek relief. And I think with the facts are certainly in our camp, it appears, and that's not always the case. So keep it up. I will keep you apprised, obviously, and I'm going to contact the council about what I spoke about, and you do the same. And if you want to reach out to me, feel free to reach out to me. If you have any questions after this is posted, please post them, and I'll try to answer them. Otherwise, be well, everybody. Take care. And we are going to stay on top of all this. Okay, no guarantees about anything, but obviously you can see that we will stay on top of it. So we being us, me and you. Anyway, everybody be well, take care, and see you soon.